Good afternoon, delegates. I'm Ruthi Rajan, Deputy Editor of The Oath Legal Magazine. For those of you who are joining us for the first time, the Oath GC Talk webinar series is an initiative by The Oath Magazine. Thank you for joining us for the session, which is in association with the law firm OGH Legal. The session will focus on COVID-19 and dispute resolution, statutes of limitation and change of circumstance in the UAE Courts, led by Mr. Mohammed El Ghateet. Mohammed El Ghateet is the founding partner and managing partner of OGH Legal. He has 2 decades of experience representing clients before local courts and DIFC courts in complex litigations. He regularly acts as arbitration counsel and arbitrator on a broad range of transnational disputes in various sectors. This includes real estate, construction, oil and gas, IT, hotels, supply chain, and media. Mohammed has also acted as a UAE law expert before English, Irish, and Australian courts. He is recognized as a leading disputes practitioner in Chambers and the Legal 500. To give you a quick overview of our session, businesses across the UAE are facing up to the unprecedented challenges brought about by the pandemic. In this webinar, Mohammed El Ghateet will discuss 2 topics, although essential, have been slightly overlooked in terms of coverage in the current crisis. The first is the statutes of limitations or prescription periods on claims, and the second is the principle of change of circumstance. Creditors as well as debtors will learn about these 2 topics and how these can be utilized in their respective contractual positions. Mohammed will lead the session for the first half, and this will be followed by the Q&A session. Some of you have sent in your questions in advance, which will be addressed in the course of the session. Please note that there is also an option on the right side of your panel on both the laptop and the phone to send in your queries. As it is a session that is scheduled for 1 hour, we would request you to send in your queries that are relevant to our discussion today. Over to you, Mr. Mohammed.
Good afternoon, everyone. Thank you all for joining us. I understand that some of you are joining us from overseas. I hope everyone is safe and healthy during these testing times. Thank you, Ruth, for the introduction, very humbling, and thank you in particular in relation to your invitation for attendees to submit their questions. I'm a big believer of dynamic discussions. Obviously, with having something online, that does make it a bit difficult, but hopefully if you send in your questions, then Ruth can tell me those questions at the end of the session or the second half of the session, and then we can discuss them with you all. So without further ado, let's start with the topics of today. As Ruth mentioned, we're going to discuss 2 topics, statute of limitations and change of circumstance. Now, I suspect some of you will have questions whether there is sufficient common ground between those 2 topics to be dealt with in the same session. I confess your concern is, or your query is probably very fair and valid. There's not a lot common between those 2 principles. However, what I think is common, and what I hope you will agree is common ground, is that both of them are only a couple of the various matters and issues that enterprises and corporates all over the world will have to grapple with in the face of COVID-19 and the related protection orders and guidelines issued by governments all over the world. So that's the common ground, and let's deal with those 2 principles from the perspective of COVID-19 and the protective measures taken by governments all over the world, particularly obviously the UAE, in the application of those principles, and what should enterprises be looking at and considering in respect of those 2, I think, important principles. So let us start, if we can have the next slide. I should say, we tried just before the session for me to take control of the slides. I'm afraid our attempts failed because of technical difficulties, so my colleague will be controlling the PowerPoint as I go through it, so you will forgive the slight interruptions in the flow, but I hope you forgive us for that. So, as I said, let's start with statute of limitations. If we go to the next slide, I raise the following two questions. What are statute of limitations, and why are they even stipulated upon in local and international jurisdictions? Now, all of you with a legal background will know that statute of limitations are the periods during which a right exists, a right to be pursued, and the period, once it lapses, is extinct and cannot be pursued. However, in law, there's a slight local quirk, and for many Arab states, which is that during the statute of limitation period, a right obviously exists. However, upon its expiry, a right is not extinguished. It still exists. Simply the ability to pursue that right, which is precluded or prevented. That's a very important point for reasons that we'll get into a bit later. So just a quick summary or a brief of what is limitation period under UAE law. It's the period after which a right cannot be pursued. So why do jurisdictions and legislations all over recognize statute of limitations? Well, I'm sure many of you will agree there are many reasons, many justifications. However, recognizing the influence of Sharia law on the UAE, the primary purpose and objective behind including statute of limitations in the realm of commercial and civil transactions is to protect commercial positions, to preserve commercial positions, and to ensure that you do not face a claim after years of thinking it has been either waived or you have no longer predict it being pursued by the counterpart. Now, the obvious question, if we go to the next slide, the obvious question is, you probably all know about the concept of limitation periods, but are there exceptions to it, given what we are all facing now, locally and globally? Well, I get to that answer to what probably is the main question in a few minutes. But let us start first with going through a number of what I think would be the most important, most relevant limitation periods out of the many limitation periods applicable under UAE law. And I have selected a few of them, and for even a fewer number, I will delve into a bit more detail. And again, for the question answer session, part of this session, which we hope will be half of it, please highlight the ones that you are more interested in, or if even there are ones that are not mentioned in the slides and I don't cover, please feel free to raise and we can deal with in the specific, in the Q&A session. So, as you will see in this slide, there are many sources of statute of limitation periods. There is the Federal Commercial Code, there is a Civil Code, Maritime Law, Employment Law, and many others. So let us go on to the next slide, where it has the two umbrella long statute of limitations. And here we have to differentiate between contractual claims or claims arising out of contractual relationships and non-contractual or tortious claims. Again, claims arising out of non-contractual relationships. We'll deal first with the contractual ones. And I said the two primary limitation periods, the two umbrella limitation periods, are limitation periods relating to claims arising out of civil contracts, which are 15 years and probably are the longest. They are the longest. And claims arising out of commercial contracts, which are subject to a slightly shorter limitation period, which is 10 years. Now, these are the two umbrella limitation periods. There are, as you will see, specific shorter limitation periods relating to specific or specialized contracts. Let us first start with employment contracts, which is the employment, which is the next slide, yes. Sorry. For employment type claims, the legislature has set a fairly short period, which is only 1 year. So an employee or an employer can only sue each other pursuant to the employment contract within 1 year of the accrual of the right. And I'm emphasizing that point because very critical to the statute of limitation period, as I'm sure you will all agree, is the time on which the counter starts to run, so to speak. And for purpose of employment claims, it is from the time the right accrues. And that is very important because a lot of times I have seen in practice, in court cases, where companies instructing clients come and tell me, well, the employment contract only ended yesterday. We want to sue them or sue the employee in respect of breaches that he has committed a number of years ago. And given that things have gone bad, we want to pursue those claims. And my answer to them, it is irrelevant. Simply put, it's irrelevant, the date of the termination of the relationship, but rather the date of the accrual of the right. And the flip side is also true. So if an employee is trying to pursue a claim for unpaid salaries going back to a year, or not a year, but rather 2 years before his termination, obviously now he's more willing to pursue his claim before local courts and pursue his rights formally. And if he pursues or he attempts to pursue that right, his attempt will be futile because the judge will look at the date of the asserted unpaid salary. If it is 1 year or more beyond or before the date of his launching or commencing of proceedings before the court, his ability to pursue that claim will be prohibited because of the passage of that 1 year period. Next slide, we have insurance claims. The standard period for insurance claims is 3 years. And that's pretty plain vanilla. And everyone who works in the insurance industry would know about that statute of limitation period. However, it's important to note that there might be another statute of limitation period, which is the following. Now, imagine that you are the insured company and you want to invoke an insurance policy against your insurer. Pursuant to the law, you have 3 years to pursue that right under the insurance policy or insurance contract. And indeed, your right to pursue your claim is a valid one and it will be permitted by the law. However, it is important if you are acting or if your in-house client is the insurance company, that there might be another separate, possibly longer, possibly shorter limitation period, which is the underlying contract between your insured client and the third party, or the underlying event if it's a tortious claim. Let me give you examples for those. If your insured client is a developer and something happened with his development because of the fault of an engineer, for example, and that fault was insured by the policy, and at the same time, naturally, the developer could sue the contractor or the engineer for his fault in the construction. Now, normally what would happen is that the developer will invoke his policy from the insurer, get his money, get his coverage, and then the insurer will subrogate the developer's claim against the contractor. Now that subrogation claim will be subject to whatever that contract, that underlying contract's limitation period is, whatever it is, 10 years, 5 years, or however long or short that period. So you have to be always conscious to that. Equally, if you are insuring against tortious liability, for example, if the insurance policy invoked is for accidents and the insured party gets paid out of the insurer and the insurer now goes against the other party, the third party causing the accident. Now, under tortious liability, there's a special short limitation period. So the insured party will have to ensure that it is pursuing that subrogation claim within proper time and is not time barred. If we go to the next set of types of claims, is claims relating to checks. Now, many of you will know that there's a validity period for a checks to be presented to a bank for encashment, and that is 6 months. Now, what I've come to learn is a lot of in-house counsel when advising clients, in-house clients, are not conscious that even if that 6 months period lapse, your right to pursue a claim under the check remains valid for a further 18 months, with a total of 2 years from the date of the check. That means for a period of 2 years, you can still file a case. In that scenario, it will be a summary court payment order type case against the issuer of the check, be it a company or an individual or both, within that 2-year period, and your right will be valid and protected. Next slide, we have maritime claims. Now, those of you who work in maritime matters will know that there are close to half a dozen, or not, maybe not half a dozen, but close to half a dozen limitation periods, different limitation periods applicable to specific and specialist type claims under or pursuant to a maritime contract. The 1-year period mentioned in the slide is the broad, simple shipping claim for shipment of goods. So that is subject to a 1-year limitation period. Now, next slide, we talk about decennial liability. Those of you who are involved in the construction sector will obviously be very much aware of decennial liability. It's a strict liability. It's a strict liability in relation to structural integrity of a building or any structure, and it's for 10 years. Arises, okay, when do the 10 years start to run? Now, there are 2 potential periods, and there's case law potentially supporting both, which is the date of completion of the works and the date of handover. Now, normally those dates, I will not say coincide, but they're fairly close. However, in some projects, particularly in power, in big power plant projects, etc., when the structure is only a very small part of the project, the differentiating date between those 2 events becomes potentially quite critical. And from the contractor side, one will have to look at insurance, how long will the insurance coverage need to be maintained, etc., etc. From the employer side, you would have to see, well, if I have an issue to raise, when does the 10-year period actually expire? So it's very important to note those slight quirks. The next limitation period is in relation to, so next slide, please. So next relates to supply contracts. Now, again, it's a 1-year period, and the assumption here, particularly with shorter periods, the assumption is that the right has been satisfied, or the obligation rather has been satisfied. That is the assumption under the law. Next slide deals with guarantor and guarantee type relationships. Now, the law here is clear. There's a stipulation in the Civil Procedural Code or Civil Code that guarantees have to be triggered or have to be invoked within 6 months, particularly usually inability of the original to commit to his obligation. However, I should add that for Abu Dhabi courts and pursuant to the courts have applied a longer period of statute of limitation, which goes up to 1 year, relying on specific principles and statute stipulations in the UAE Federal Commercial Code. So you have to be conscious as to those two potentially competing periods. Now, I had mentioned at the very start of this part of the presentation that there are claims, contractual claims and non-contractual claims, tortious liability type claims. And this is the last slide in this section. And the applicable statute of limitation period is 3 years. Now, again, particularly for tortious claims, the question arises, when does it start to run? The answer is potentially two different dates. One, the actual event taking place, the event giving rise to a tortious liability. But there is also a potentially later other date, which is the date on which the victim realizes either the impact or the actual event taking place. And these two dates obviously will be later than the original date of the event giving rise to tortious liability. Now, I appreciate that one could think, well, for companies and enterprises, the idea of tortious liability might not necessarily be valid or relevant. That is the better characterization. They might not be relevant for contractual claims for construction of contracts or power plants or ports or airports. But in reality, I have seen a lot of tort type claims arising out of contractor developer or contractor subcontractor relationships because of gross mistake, because of negligence. And these two types of circumstances permit, albeit in narrow possibilities, but indeed they permit a tort type claim which is outside the realm of contractual claims. Now, I don't want to get into too much detail on that one because it's not necessarily relevant to the subject matter, but the attractiveness of a tort claim in a construction contract is that elements of limitations of liability are thrown out of the door. There's no cap, or a cap on liability would not be applicable to tortious liability. Issues relating to foreseeability are again thrown out of the door. Issues relating to proof of a burden of proof are changing. So there is an attractive option here when the circumstances permit. Now, these are the last slides that we dealt with purely limitation periods. However, if we move to the next slide, there are other time bars. They're not limitation periods per se, but ultimately there are periods when they expire, the party's ability to pursue a right or to preserve a right escapes it or is waived or diminishes. And here are a few examples. This is not an exhaustive list, but a few examples which are particularly relevant, as we will see in a moment, for COVID-19 and the related circumstances. One is appeals. Now, I'm sure many of you will have had a case or two being decided upon during the past 3 months, and there's a period of 30-day appeal stage. So if the court of first instance judgment is not favorable, well, you have only 30 days during which you can file an appeal. Now, there are potentially shorter periods for special types of claims like payment orders and summary court judgments, which are even shorter. But in any event, there's a period here that you have to deal with. Cassation appeals, same idea. Specific time period, if you do not file your appeal within that time, in fact, if you don't pay the court charges within that time, your ability to appeal an unfavorable judgment diminishes, or actually is completely lost. Attachments. This is a unique feature of Arab civil law, where if a party seeks to prevent the encashment of a bond, If a contractor learns that an employer is about to liquidate his bond, he procures an attachment order against the bond, and then if he is successful in imposing an attachment or persuading the court to impose an attachment on the bond, preventing its encashment, he has 8 days during which he has to file or commence substantive proceedings. Now, if you do not file the substantive proceedings within that 8-day period, the attachment that you have successfully procured and imposed on the bond is reversible. So that's again a period, if you don't act within, problems will happen. Challenges to arbitral awards. We are all now, I'm sure, have come across and used the new arbitration law in the UAE. That arbitration law explicitly stipulates that a judgment debtor or an arbitral award debtor only has 30 days during which he has to file a case seeking, or an application rather, seeking the setting aside or nullification of arbitral award. If that period lapses, there are complications. I will say that there is always, for this case particularly, there is a potentially an alternative option, but again, not for today's session, unless someone is interested in it and we can deal with it during our Q&A session. Lastly, contract notices. We are all accustomed to contracts sometimes saying a right cannot be preserved except if you invoke it and notify the other party of your reservation of right to invoke it, or a determination of engineer becomes final and binding if you don't challenge it. And these contractual notices, again, are time bars technically that you would need to act within. And if you do not, then your rights diminishes. So the question is, now, having listed a number of time bars, having previously listed statute of limitations on the expiry of which your right, your ability to pursue your right is lost. So how does this all fit within COVID-19, and particularly given the various restrictions, protective restrictions issued by governments locally and internationally? Which leads to the question that I start with: are there exceptions to all of this? And this takes us to the next slide. Now, let us first start with statute of limitations. Now, as a matter of general principle of law, statute of limitations are subject to exceptions which are potentially quite broad. Indeed, the law permits a party which has valid, acceptable excuse to suspend or stay the counter of a statute of limitation. Now, one could ask, well, is it a subjective test? Is it an objective test? Is it something that has to be general, or can it be unique to the particular party which has a right which is potentially exposed to expiry of a limitation period? And the answer is all the above is applicable. There's a subjective test, there's an objective test. The circumstances could be unique to the individual or to the party that holds the right, and it could be general to the whole society or the market. Now, the effect of a stay on proper invocation of these special circumstances is that the period of the limitation period stops to run. So you have to put a pause button basically on that period. So if there are a 10-year period and then that exceptional excuse that is acceptable starts, you put a pause button, and for that intervening period, the 15-year limitation, the 5-year limitation, the 3-year limitation does not continue to count. So that's the effect of a stay. Now, there's another potential scenario where not only is there a stay to the limitation period, but the limitation period actually is stopped. Now, the only relevant procedure by which a party with a right can stop a limitation period is by it pursuing a substantive claim. The only other exception is if the counterparty, the debtor, acknowledges the right or acknowledges the debt. And in that case, in both those cases, a new period of statute of limitation starts to run. Now, there are instances where a longer period starts to run, but I don't want to get into too much detail here, just conscious of time. For the purpose of discussion, again, in Q&A session, we can deal with any specific queries. If we now go to the next slide, and let us think about what has been happening and how could these be excuses or valid excuses for purpose of limitation period and valid excuses for purposes of these other time bars that I mentioned. Now, we know for the UAE, there has been closure of courts, closure of arbitration centers. So the question is, well, I want to pursue my claim. I'm about to face a limitation period that's about to expire. What do I do? Well, given that both the courts and the arbitral institutions, although closed physically, have been accepting online applications, probably the first point will not be accepted as an acceptable excuse against the running of statute of limitation. The second point is closure of or delay of courier service. Now, that might be applicable in respect of contract notices, particularly where a contract requires that the notice is issued by courier as opposed to email or other means of communication. So in that scenario, and in the realities that we have been facing in UAE, where courier services, at least for a specific period of time, or April, were completely closed down or almost completely closed down, there might be an excuse here to be invoked, a valid excuse, an acceptable excuse. The sterilization program. Now, we all remember the 3-week sterilization program that occurred in UAE. People were not able to procure, were not able to even go down in the streets and get powers of attorney notarized. A foreign party could not get a power of attorney notarized its own foreign jurisdiction. So here, this could be a valid excuse in respect of your ability to pursue a claim because you could not assign a lawyer, or your ability to pursue an appeal against a court of first judgment if you wanted to change counsel. Now, in this particular last example, there might be nuisances because then we enter into the defense of force majeure. Again, I would park that for the moment, but it is something that is a possible defense. The last point is postponement of judicial hearings. Now, a lot of us will be involved in cases where our internal client or my position, my instructing clients have a claim, but they don't necessarily need to rock the boat, but then they're surprised by the other side pursuing a claim, and accordingly they decide to present a counterclaim. Now, in a scenario where the defense, which is a counterclaim, was about to be exposed to the statute of limitation, and because of the very long adjournments in the judicial hearings, they were unable to present the counterclaim soon enough because of the adjournment. That could again be a potentially valid excuse. So without further ado, I will draw a line under limitation periods for the moment. Please take me on any specific point in the latter part of the presentation. I'm conscious that I actually have gone considerably over time, but there we go. Can we go on now to the next slide and start our discussion of change of circumstance? Now, we've all seen a lot of articles being put together about force majeure, how it could be applicable, how could parties utilize it in their various contractual relationships. However, I personally have not seen, at least at the time when we jointly with Oath came up with the idea of holding this seminar or webinar, I have not seen a lot of commentary about change of circumstance in the light of COVID. So there might have been now since some writings about it, but I think it might turn out to be a very interesting alternative to force majeure, particularly because of the threshold required for an invocation of change of circumstance is fairly lower than the threshold required with a force majeure defense or argument. More importantly, that a force majeure type argument has potentially one very severe ramification, as opposed to change of circumstance, which has a number of remedies available, number of options available for the parties and the court or the adjudicator, whoever that may be, an arbitrator or a judge. So let's move on to the next slide. And here I pose a question, which I think is very important, and I'm sure many of you would have reflected on. And the question is COVID itself as a pandemic potentially the change of circumstance, or is it more the various orders, protective measures, guidelines, instructions, directives issued by governments all over the world, which is a change of circumstance? And I think it's important to differentiate between those two, because the timing of each is in a different window, and the predictability of each falls under a different type of consideration. So I think we have to differentiate between those two. I would say now, for example, in Dubai, there's no more, at least as far as I know, the considerable restrictions that were, the protective restrictions that were applicable for a number of weeks and almost a couple of months are no longer now in place. So one has to now think about the pandemic itself as a change of circumstance. Conversely, a few weeks ago, when there was a complete lockdown, the reverse was right, because the pandemic itself was not posing the change of circumstance. It was the protective measures taken by governments in the UAE and globally that was the issue. So we should ensure to differentiate between those 2 points. Let's park the answer to the question and jump right into, given time, to the next slide, and the 5 essential elements or conditions of a valid invocation of a change of circumstance type argument. The first one is a type of contract. Is it valid, or is it possible to invoke that sort of defense in any contract? The second one is foreseeability, clear and simple. The next one is private versus public impact. Fourth is ability to avoid, and the fifth is the ramifications of the event. Let's deal with on each in turn quickly. The first is continued versus immediate contracts. Can we go to the next slide, please? Now, contracts that require a long, not a long, but a deferred performance would be appropriate for purposes of invoking change of circumstance type arguments. However, immediate contract, like a sale and purchase agreement, the plain vanilla type where change of title, transfer of title happens in exchange of funds, and that's it, you cannot raise that argument, even if a payment plan comes after and your obligations to pay are deferred. Next point, public circumstance. I'm sorry, I'm going to have to gallop through them to ensure, first of all, that I finish in time and that we have sufficient time for the Q&A session. Public circumstances, yes, indeed, they have to be public. It cannot be unique for a particular entity or unique for a particular contract, but rather it has to be a very public effect type circumstance. The next slide, it has to be unforeseen, unequivocally. And that goes back to the issue of, sorry, I think we're on the wrong slide. Yes, so it has to be unforeseen. If parties could have foreseen the change of circumstance, they cannot later raise the point, obviously. The next point is the next slide, and indeed the next point as well, is that the circumstance should be one that could not be avoided. Now here, the issue of reasonableness of what could have been applicable or expected from a party to avoid the effect of a change of circumstance. Let us give the example of the closure of ports. Now, if a supplier was obliged to supply product to a specific port where the purchaser was situated, and that port said, in 10 days' time, we're going to close the port because of COVID. Now, theoretically, one could say, well, the supplier should have spent more money to ensure that the shipment arrives in time before the port closes. Well, that's a reasonable idea, but the question is how much cost would have been involved? Is it reasonable to incur that cost? And what is the degree of the cost versus the potential profit or value of the contract? So there's going to be a subjective test that will be applicable here in terms of ability to avoid. And that's a fantastic segue to the last point, which is hardship or serious loss. This is the most important test in all of the elements that I mentioned about a valid or a successful invocation of a change of circumstance type argument. A party trying to invoke it will have to show the degree of that unavoidable and huge loss. And this is probably where a lot of the friction and a lot of the contention in cases where you invoke a change of circumstance type argument boil down to. Now, I have to say that there are a few points that I want to make in respect of these principles, but given time, I'm rushing through them, but hopefully I can focus on ones that you are more interested in the Q&A session. The last slide that I want to deal with quickly, before I hand over to Ruthie for Q&A, is that the change of circumstance is not only a sword, but it's also a shield. So a party that believes that it has faced a change of circumstance should not only assume that it could use it for one but not the other. Rather, it could use it for both. It could elect to use it as a sword for purpose of asking an adjudicator to adjust a contract price, asking for an extension of time for performance of a construction, asking for a delayed performance of obligations like the supply contract I mentioned before because of the closure of a port. But it can also be used as a shield where the counterparty is claiming for damages for breach of contract, and you use the change of circumstance as a shield to protect your client, your in-house client, against that liability claim. Now, a few last words. It's important, notwithstanding all what I said, to look at your contract, because although the contract cannot give you less than what I just mentioned in terms of protection of a successful invocation of a change of circumstance type argument, but it can give you more. You should always now look at issues of notices in terms of limitation period. If you have a right that you're not sure how it qualifies, what limitation period it's applicable to, you have to consult your external counsel. And going forward, you have to be conscious, as I mentioned, that it's no longer the instructions or the protective measures taken by governments all over the world, but now we see governments relaxing those restrictions. So the question becomes, is COVID itself a change of circumstance? Thank you, and over to you, Ruthie.
Thank you, Mohammed, for sharing your insight with us this afternoon. A reminder again to the delegates that there is an option on your panel to send in your questions. So if there's anything specific that you would like to ask Mohammed or that you would like him to elaborate on, please do type in your queries and we will be able to answer it. We have a few more minutes left, Mohammed, so I'm just going to raise a couple of questions that have come in. First one is, it's a bit of a long one. So in case of contractor's bankruptcy, and if the employer still has retention money in hands, is there any resort under law to withhold any amount to cover potential cost that may be incurred under decennial liability? Were you able to catch that?
Yeah, I did, but I will answer it, but I want to emphasize it's not necessarily relevant to today's discussion. But the right to withhold has to be justified by an immediate claim or immediate entitlement. It cannot be to secure a future potential entitlement. Otherwise, you are exposing yourself to even an interest claim or damages for interest claim. So you can only withhold the right or withhold money if you have an accrued right now. Otherwise, that withholding would be unlawful and would only become lawful once the right that you are asserting to protect yourself from actually materializes.
Okay. Next one, I have more of a statement, probably it requires your comment on it. For contract notices, I got to know that some verdicts in UAE still support the entitlement, even if one party acts in non-compliance with the contract notices, civil contracts to be precise.
Sorry, can you repeat that?
Sure. For contract notices, I got to know that some verdicts in UAE still support the entitlement, even if one party acts in non-compliance with the contract notices, civil contracts to be precise.
Yes, so thank you for that. Well, actually, there's a lot of contention. The position is not clear, both for commercial and for civil contracts, particularly in relation to notices. The bottom line would become what does the notice relate to, and whether or not the party who is claiming the right can show that the objective behind the notice has been satisfied by other means.
Okay. Could you please re-explain about when to invoke change of circumstance? Someone has asked if you could quickly re-explain that.
So, well, that means that I was very bad in my presentation. So I'm worried now. Well, that's what we were trying to say. So you can only invoke a change of circumstance if all of these elements have been satisfied. So you have to look at a fact-based review of the particular fact and the matrix of facts, the contractual obligations, whether they have been impacted by either COVID or the government regulations. So one has to look at the facts. Sometimes it's the specific contract with two parties. One of them, COVID has become a force majeure, and for the other is a simple change of circumstance. So it's dangerous to make any general remarks except when one actually looks at the facts, looks at the obligations.
Okay. A reminder once again to the delegates that you can send in your questions. We still have a few more minutes. Is there, next question, Mr. Mohammed, is there any declaration in UAE that clearly announces COVID as a force majeure event? I know it.
I assume declaration meaning a judgment, not yet.
Okay. And in the construction industry, even before the COVID-19 era, we are used to using tolling agreements to put a hold on claims so that we can focus on performance of the contract. Are these agreements valid and enforceable under UAE law? And is there a possible solution when it comes to staying of limitation periods?
Very good question. Tolling agreements are a very touchy subject in my experience. They work in a lot of jurisdictions across the board, foreign jurisdictions, I mean, but they're not necessarily right, or their usage is not necessarily appropriate for Arab jurisdictions. And the reason why is the following. Now, for those who know tolling agreements, it's the agreement where you enter into an agreement with your counterparty. Again, let's use construction as an easy example, where you enter into an agreement with your employer, or your employer enters into an agreement with you, where you agree on extending the limitation periods, particularly, for example, the tortious claim, which are much shorter, 3 years. Now, in other jurisdictions, the rationale is, let us focus on the performance of the contract and let us agree to toll the potential dispute between us to a later date once everything is done, once the completion is done, etc. Now, the problem with UAE law and Arab law, for that matter, is that an agreement to extend a limitation of statute of limitation before, and I want to emphasize, before its expiry is invalid, unenforceable. Accordingly, if you envisage extending a limitation period, you cannot do that except after it expires, which obviously would require both parties to be really in a good mood to allow or permit the counterparty to extend the limitation period. So tolling agreements, the short answer to your question is tolling agreements in the manner that I have seen applicable in other foreign jurisdictions are not applicable here. They do not work. Now, you can tweak them to make them work, but that's a long story.
Thank you, Mr. Mohammed. There are a couple more questions that have come in. Is there any resort under law or a precedent that in claims under COVID, there can be a potential to claim for costs?
So can you repeat that? Sorry.
Yes. Is there any resort under law or a precedent that in claims under COVID, there can be a potential to claim for costs?
So I assume here costs of what? I mean,
doesn't specify, unfortunately. Yeah.
Yeah. So I give you a broad answer. Well, if costs here we mean costs arising out of the contract, well, yes, that's the role of the judge, where the judge comes in and adjusts the obligations of the parties. So if I were obliged to supply metal, and I supply it to a local contractor in the UAE, and I buy it from China, and because of the closure of ports in China and the closure of ports here, I can raise an issue about that I had to buy it from another jurisdiction that does not have their ports closed. There might be a significant added price, to the material, but also in terms of shipping price, etc. Now that additional cost will be part of my application to the court, seeking the court to adjust the price that I am supplying my end user with, and tell him I was supplying you a metric ton of steel for X. Now I want X plus 1 because the price is actually now double X, and it will be to the court's complete discretion how much or how far the court adjusts the price.
Okay, thank you, Mohammed. Are the courts granting attachments on assets in the current COVID-19 situation?
Thank you for the question. Again, not necessarily relevant, but I'm happy to deal with it. Yes and no. We have seen different courts of different emirates operate very differently. So I can tell you that in Abu Dhabi, in my experience, in the past 2 months, we've been doing a lot of precautionary attachments against bonds, against assets, etc., etc. And my experience that Abu Dhabi courts have been fairly keen on not permitting attachments just because of COVID. And indeed, the judgments issued are not to quote unquote reject, but rather defer ruling, saying please make an application again after COVID. Now, other courts have taken a different view in the UAE. So I would say that there's no general answer. It would depend on which emirates you're applying to and what is the type of attachments you are seeking. So attachments against bank accounts in Dubai have been fairly successful. Attachment against personal assets of individuals have not been. Attachments against commercial licenses have not necessarily been successful. So it depends. I should say, however, all these comments that I made have significantly changed since last week. Indeed, we've had a lot of pending applications that were suddenly approved after the government relaxed considerably the protective measures. So I think the tide is now going back to normal. And if you have a valid attachment application, you should be confident it will be granted.
Thank you, Mohammed. I'm conscious of time, but can you take one more question if I can read that out?
Sure.
Yes. How is a force majeure clause considered by the courts here to justify suspension or extension or exception of limitation period?
So a force majeure, again, going back to a general principle of law in the UAE, pacta sunt servanda. So parties' agreement should be upheld unless it contravenes with mandatory principles. Now, if a party or if parties agree on a specific protocol in the event of a force majeure event, and they say, well, the first protocol is that we suspend, the second stage is X, Y, and Z, the courts will happily uphold parties' agreement in that regard.
Okay. Thank you, Mr. Mohammed. Dear delegates, we've come to the end of our session, but I'm sure if there are any other questions, you can definitely direct it to us, and we can work with the firm and Mr. Mohammed to answer that for you. With that, we've come to the end of the webinar. Mr. Mohammed, do you have any closing remarks?
I hope everyone is safe and healthy, and hopefully next time the Oath will hold face-to-face webinars in the very near future, when everything is I hope, much better all around the world.
Thank you so much. Yes, that's definitely our hope too. We, as much as the online platforms are great, we definitely miss meeting together in a room and having a chat. Thank you, Mohammed, for taking us through the topic and offering practical advice on statutes of limitation and change of circumstance in the UAE courts. Our sincere thanks to the firm OGH Legal, especially to Mohammed for leading the session, and also to his colleagues Andrea and Yasmin at the firm for helping us put up this webinar. And also to my colleagues Sunil and Sandhya at Niche Publishers for their support in ensuring a seamless session. Thank you for joining us again this afternoon. We will keep you posted of other events in the series. We wish you good health. Have a great week. Thank you. Thank you.